Well, it's very much a delight for me to be with you here at NYU. I love New York, so any opportunity I have to come in this direction is a welcome one. Thank you to the Law and Religion Society, as well as the other sponsoring organizations for this opportunity to speak about what I think is a very intriguing case, as well as an intriguing constitutional provision that governs its evaluation. The Establishment Clause, possessing as it does a rather controversial interpretive history, gives us plenty of grist for the mill of provocative discussion. So I hope we can accomplish at least that much this evening. And by way of forecast for you watchers, I think my prepared lunch should run around 45 minutes, after which time I'm happy to have discussion for as long as you want to continue. Or if you'd like to chase me out at that point, that also will be fine. I'll leave that up to your preference. Okay, well, beginning then. The Greece versus Galloway case that was argued last Wednesday at the Supreme Court, of course, treats this venerable practice that we call legislative prayer. The case presents a mound of interesting issues, all of which could be talked about at quite some length, so I'm going to, by necessity, be selective in my focus as to what I'm looking at, rather than trying to be comprehensive on all the issues that could arise in the case. My aim this evening is, in addition to presenting a focused case discussion, it's also to interrogate some of the suppositions that are embedded in contemporary Establishment Clause discourse. And in the process of doing that, I expect we'll touch on some themes in the broader and contentious conversation over the intersection of law and religion. So all of this, I trust, as I said, I think will at least be provocative and perhaps even interesting. Let's hope the latter as well. As I suggest that we might do well to reevaluate whether this idea that we need to chase theistic discourse off the public stage is well considered. And additionally, I'd like to ask the question of whether this usual description of the conflict, that is, between religion and non-religion, is, after all, what's going on, and an accurate description thereof. We might say that legislative prayer is the last redoubt for theological expression in the arena of government discourse, the one remaining area in which theistic reference is still permissible in state discourse. This is an anomaly, I think we recognize, but I think there are a couple of reasons for this as a holdout. First of all, it's hard to plausibly condemn this practice in view of the fact that we have 225 years of national history containing an uninterrupted and ubiquitous practice of legislative prayer at all levels of government. Makes it a little tough to say, this is not consistent with the fundamental law of the United States, when there has never been a time in the history of the United States, so long as we've been operating under the Constitution we have, in which this practice wasn't in evidence. So that's one reason. But secondly, the Supreme Court has already cleansed all of public life, essentially, and in every other context, from dog catcher on up, from reliance on divine precept and authority. So there's a sense in which allowing this ancient prayer practice to continue is more of an accommodation of, ceremony than anything else. More kind of a quaint reminder of our benighted past, or a token accommodation to the religionists among us. So fleshing out this second point, we're permitted to petition God's blessing and guidance on our government endeavors. But after we've said amen at the end of the invocation, we are then bound by Supreme Court edict to thereafter in our government pursuits to act as if God does not exist, or at least that he's not relevant to anything that we're doing. And to the extent that state officials thereafter would proceed in a way that's perceptibly relying on theological precept, to that extent, and for that reason, the government action at issue is unconstitutional. So there is a bit of thick irony in play in this area of the law. Sure, we can briefly address God in public, so long as he thereafter sits tight in his First Amendment cabin and disregards our petition that he participate in our government endeavors. Now Another point of introductory interest before getting into the substance of the law in this area is that in the Grease versus Galloway case, this case involves litigants on both sides taking positions that are at least implicitly rejecting Supreme Court Establishment Clause tests that are arguably relevant to the analysis. The town of Grease, of course, challenges the relevance as well as the validity of the Lemon and the endorsement tests, which we'll both discuss here in a moment. But more notably, the plaintiffs who sued the town, who are the respondents now before the Supreme Court, have, after 5 years of litigation, in submitting their briefs to the Supreme Court, pulled an about-face as to their legal theory. So they abandon the argument that they have steadfastly proffered since the time of their filing of their complaint, which happens to also be the claim of, or the theory upon which that they prevailed at the Second Circuit. And specifically, their argument then was that the town's prayer policy violates the endorsement test. That is to say, a reasonable observer would think that the town was endorsing Christianity by having this prayer practice. This is no longer their claim. Now instead, and in its debut performance before the Supreme Court of the United States, they urge that the clergy invocations that initiate the board meetings of the town coerce them into participating in a religious exercise. Now, leaving aside, at least for the moment, the creativity and unprecedented form that that particular argument takes as they present it, I'll just now instead note that the, shall we say, procedural uniqueness of changing your theory of the case upon reaching the Supreme Court might tell us something, and I think that is specifically that the respondents have discerned that the endorsement test, although serving them so well at Foley Square in front of the Second Circuit recently, is not necessarily one that is going to be happily embraced by the Supreme Court, or at least not in application to this particular case. And this switcheroo in legal theory also conforms to the speculation, at least that existed before the oral argument, that a refinement of Establishment Clause jurisprudence may be in the offing in this case. Not that it's necessarily going to happen or even likely that it's going to happen, but it's certainly possible. And the reason it's possible is, and considered as being an outcome that we could reasonably anticipate, is because the majority of the justices, including, always relevantly, Justice Kennedy, appear to be skeptical of the endorsement test. And remember, the endorsement test was the grounds upon which the Second Circuit ruled, and the Supreme Court has granted review of that particular decision. But on a broader level, the Supreme Court's Establishment Clause jurisprudence is much maligned, and justly maligned, I would say, for much of it has no real connection to the clause in the First Amendment that it purports to be interpreting. Moreover, it's not especially coherent. The case law tests, specifically the Lemon and the endorsement tests, have been amply ridiculed, not only by commentators in the Academy, but also by the justices themselves, as well as some vocal lower court justices who are placed in the position of having to make do with these tests that the Supreme Court has been giving them, which essentially give rise or have the effect, paraphrasing Judge Easterbrook, of empowering each judge to announce his own gestalt while posturing, of course, as if actually making an objective legal determination. So will the Supreme Court take the occasion of this case to give a stab at a more uniform and sensible Establishment Clause standard? My own view is that while there is a majority of justices on the court that find the current arrangement unsatisfying, I'm not so sure that there's a consensus as to what should replace what we now have. So I don't think anything quite as ambitious as a significant renovation is in the works, and after last week's oral arguments, I'm only kind of further reinforced in that skeptical posture. By the way, back in 2005, before the two Ten Commandments cases were argued before the Supreme Court, there was similarly at that time the expectation maybe these cases are going to yield remedial effect in Establishment Clause jurisprudence. Well, as it turns out, their combined effect was instead to multiply the uncertainty as to what in the world the rules really are in this instance. One Ten Commandments case involved the court applying the Lemon test, and it invalidated the Ten Commandments display. And in the other Ten Commandments case, the Supreme Court did not apply the Lemon Test, and it validated the Ten Commandments display, both cases being announced on the same day. So we'll see what the Supreme Court gives us. Prognosticating is a dangerous business, so I'll just say we'll wait and see what comes. Well, all of that was by way of introduction and background, so now on to the constitutionality of legislative prayer. In 1983, the Supreme Court issued its decision in the Marsh versus Chambers case. So this was a case that involved a challenge brought by an atheist Nebraska state legislator to the state policy that it provided for legislative prayer. The state of Nebraska had hired a Presbyterian minister as its chaplain to offer prayers at the beginning of each legislative session in the Senate. And he served in that capacity for 16 years, uninterrupted, by the time that the Supreme Court adjudicated the case. During those years, he offered identifiably Christian or Judeo-Christian prayers. So the question was, did that circumstance constitute an Establishment Clause violation? Well, at the time that the Marsh case was presented to the Supreme Court for review, the Lemon Test was the analysis by which the court evaluated Establishment Clause challenges. And those of you who've taken con law or First Amendment or some such case, or class rather, know that the Lemon Test has three prongs that effectuate its secularism imperative, about which more a bit later. But those three prongs evaluate whether the challenged governmental activity has a secular purpose, has an effect, primary effect, that is secular, or presents an excessive entanglement between government and religion. Well, notably, Chief Justice Berger, who wrote the Lemon opinion that gave us that Lemon Test, was also the author of the Marsh legislative prayer case. And in that Marsh case, Chief Justice Berger dispensed with the Lemon Test that he had authored. It is, after all, difficult to conceive how a legislative prayer practice calling upon God for guidance and blessing could be found to be secular in purpose and effect, considering that the Supreme Court seems to conceive of secular basically as godless. So the Supreme Court instead opted to treat legislative prayer as unique and employed for its evaluation in the Marsh case, not Lemon, but a historical review of the circumstance of legislative prayer in our national history. And the court proposed that its ubiquity through time and place surely instructs us as to what the Establishment Clause does not forbid. The court wrote that the opening of sessions of legislative and other deliberative public bodies with prayer is deeply embedded in the history and tradition of this country. The court elaborated as follows. From colonial times through the founding of the Republic, and ever since, the practice of legislative prayer has coexisted with the principles of religious establishment and religious freedom. The court, relying on the First Congress's near simultaneous authorization of a paid legislative chaplain and the adoption of the First Amendment, the court reasoned that historical evidence sheds light not only on what the draftsmen intended the Establishment Clause to mean, but also on how they thought that clause applied to the practice authorized by the First Congress. Their actions reveal their intent. Subsequently, in the opinion, the court stated that in light of the unambiguous and unbroken history of more than 200 years, there can be no doubt that the practice of opening legislative sessions with prayer has become part of the fabric of our society. To invoke divine guidance on a public body entrusted with making the laws is not, in these circumstances, an establishment of religion or a step toward establishment. It is simply a tolerable acknowledgement of beliefs widely held among the people of this country. As Justice Douglas observed, quoting him here, "We are a religious people whose institutions presuppose a supreme being." End quote. So that's the Supreme Court in Marsh. So while legislative prayer would appear to be an obvious violation of the Lemon Test, the Supreme Court said it's not a violation of the Establishment Clause. That might lead one to think that perhaps the Lemon Test doesn't well convey the meaning of the Establishment Clause. I, for one, think that that's probably right. But nonetheless, others propose that Marsh's incompatibility with Lemon mean that not Lemon, but Marsh is incorrectly decided. But in either event, both cases continue to stand in tension Lemon continuing to serve as an effective bludgeon in the secularizing of public life, while Marsh apparently forbids Lemon analytical access to the arena of legislative prayer. Now, since the Supreme Court announced its decision in the Marsh case, there have been a few developments that merit our attention before we get to the Grease versus Galloway case. And the first of which is, in 1989, which was 6 years after the Marsh decision was handed down, the Supreme Court decided the case of Allegheny County versus ACLU. This is the case in which the court famously found that the Christmas creche display in the courthouse was unconstitutional, but the menorah that was posted outside of the city-county building was constitutional. But anyway, for the notable aspect of that case for our purposes is that in dicta, by way of response to Justice Kennedy's dissent, the majority in that case said Marsh had vindicated the Nebraska prayer policy because the prayers that were last offered by the chaplain, Reverend Palmer, after suit had been filed in that case, didn't contain any references to Christ. So now we have a gloss on the Marsh decision that can't be found in Marsh itself, but nonetheless was added by dictum from a subsequent Supreme Court case. Second development, this is also in the Allegheny case, the court for the first time ratified the concept of endorsement as an establishment clause standard in certain cases. The endorsement test offers that the government may not act in a way that leads a reasonable observer, so-called, to conclude that the government is endorsing religion. Well, that endorsement test is, depending on who you ask, either a refinement of the Lemon test, or perhaps it's an elaboration of a critical component of the Lemon test in certain circumstances, but in either event, it's a derivative of Lemon. And the policy explanation often accompanying that test is as follows. This is from Justice O'Connor. Those who don't share the government's beliefs may feel like outsiders or second-class citizens. Okay, third development of interest is in the last few years there's been a spate of litigation over these legislative prayer policies. Just out of nowhere, suddenly we have cases coming up around the country. And this involves, since that time, circuit courts now adjudicating the cases in a way that applies the endorsement test to legislative prayer, which is arguably mistaken, remember, because the endorsement test is a derivative of the Lemon test, and in Marsh, the Supreme Court had refused to apply the Lemon test to the evaluation. Okay? So there's the setup. Now we come to the case of Grease versus Galloway. Two residents of the town of Grease, New York, represented by Americans United for Separation of Church and State, sued the town for the prayer policy that was in effect at the town's monthly board meetings. The town's practice was to invite, and still is, to invite local clergy to volunteer to offer opening prayers at the beginning of the board meetings. These clergy members being drawn from the Chamber of Commerce community directory of local congregations. Most, if not all, such congregations in the town of Grease, New York, are Christian congregations. It's just the demographic reality there. So the vast majority of the prayer givers then, with precious few exceptions, were Christian clergy. There was at once a Wiccan priestess that offered a prayer to Athena and Apollo. There was a Jewish layman that prayed a couple of times, I believe, as well as a representative who pressed the chairman of the local Baha'i congregation. But other than those few exemptions, all others were Christian clergy. And this is the subject of the challenge of the plaintiffs in the case. Well, the district court had ruled in favor of the town, so the plaintiffs appealed. And the only issue on appeal was, and I'm quoting the Second Circuit now, whether the town's prayer practice had the effect, even if not the purpose, of establishing religion. So the court proceeded as if the town's appearing to be affiliated with a religion is an Establishment Clause violation. The First Amendment forbids the town to have a certain appearance, even if that appearance is unintentional. And specifically, the court presented the analysis as follows. We must ask whether the town's practice viewed in its totality by an ordinary reasonable observer, conveyed the view that the town favored or disfavored certain religious beliefs. That is, whether the town liked or disliked certain ideas. Okay, now note that the court is making clear that the question is not whether the town engaged in some coercive activity or discriminatorily distributed or withheld benefits based on someone's religious practice or church affiliation or what have you. The town didn't do any such thing as that. Indeed, the court even explained that we ascribe no religious animus to the town or its leaders. The town's demerit is exclusively in appearing to favor certain religious ideas. Of course, the court did say that communicating a religious idea runs the risk of making one who disagrees to feel like an outsider, but that's not the crux of the legal determination. Remember, it's not a real person whose impressions matter. It's only that of a reasonable observer, which is an analytical construct, not a person that we interview to see if he's been dismayed. The court concluded then that an objective, reasonable person would believe that the town's prayer practice had the effect of affiliating the town with Christianity. So the Second Circuit, at least to that court, the Establishment Clause, as applied to this case in any event, serves as the reasonable perception of affiliations clause that forbids religious speech by the government that implies a sympathy or a favorable disposition toward a particular religious view, even if that's not what the town intends. If you've not yet discerned this, I'm not a fan of the Second Circuit's view. Matter of fact, it makes me feel like an outsider. Second-class citizen, in fact. But I've emphasized the court's ruling here at some length because this is the view of the Establishment Clause, on which the plaintiffs won, that they've now completely walked away from, now that they've gotten to the Supreme Court. That much, I think, is a wise strategy for them at this point. In my opinion, the endorsement test is neither sensible nor recognizable as a description of the First Amendment, and it's one that the Supreme Court should do away with in this case. But I'm not a big fan of what the plaintiffs are offering now either. Their innovative coercion theory, which I'll critique a bit later, isn't such a good idea, I think. But for now, as to that endorsement test, I'll explain why I think that is a test that the court needs to get rid of. There are three general reasons that I take that position. My first proposal is that the drafters and ratifiers of the Establishment Clause aim to vindicate a federalism principle that would keep the feds from messing around with state religious establishments. Moreover, it forbade the federal government in its own territories likewise to be setting up an establishment of religion. But establishment meant something quite specific at that time, and it did not mean, just as the constitutional text does not say, that it prohibits law or conduct advancing or endorsing religious ideas. Rather, it forbids laws respecting an establishment of religion. I should make clear, lest there be any confusion, I'm not arguing at this point against incorporation of the Establishment Clause against the states, but rather to say that assuming incorporation, what is applied to the states should at least honor what the historic meaning of establishment is. Perhaps even have its enforcement enthusiasm tempered somewhat by remembering the original arrangement. But Professor John Swamley has explained that the late 18th century usage of establishment conveyed two understood meanings. I'm quoting him now. One was a technical reference to monopoly status, such as the Roman Catholic Church had for many years in Spain, or to government patronage and control of the church, such as the Church of England, or government regulation and financial support of one or more churches, as in some colonies and states in early America. The other meaning of the word establishment is institution. A religious establishment is an institution of religion. So both senses of its use at the time refer to an institutional church. And thus the focus is a jurisdictional separation of the institution of the church from that of the state. Professor McConnell's scholarship similarly sets forth that the establishment of religion at the founding meant state financial support of a church, government control over the doctrine and clergy positions of the church, government coercion of religious profession and practices, including compulsory church attendance, prohibitions on worship in dissenting churches, and restriction of political participation by those who found themselves outside of the established church, as well as civil regulation functions carried out by church officials. These are what establishment prohibitions forbade at the time of the founding. That is not what the Lemon endorsement tests contain, of course. Okay, my second ground for criticizing the Lemon endorsement regime is an elaboration of a point that's already implicit in the one that I just made. And that is that the separation of ecclesiastical and civil institutions does not also mean, and would have been incomprehensible, inconceivable to the drafters and ratifiers as entailing, a banishment of theologically informed speech or justification. The separation is between ecclesiastical institutions and state, not between religious ideas or speech and state. The social milieu at the time of the founding was one emphatically steeped in theological discourse. This was just the common belief structure of the time, this being demonstrable by any number of anecdotal observations as well as the legal standards of the time. But by way of summary, as Winthrop Hudson has written, when the First Amendment was adopted, no one thought that separation of church and state implied any separation of religion and politics. And not just because of the quite standard Thanksgiving Day proclamations or the calls for national prayer and fasting, or even the congressional institution of chaplaincy, but rather because theological precept was regularly employed in political discussion at the time. Religious conviction and public policy divisible? This would have been an implausible idea to these people who drafted this instrument. And rightly so, I think. Don't we need, for coherent action in matters of social design and regulation, a conception of the nature of the human, the just bounds of the state, a conception of right and wrong, and a view of the world that grounds all of these convictions? And if so, one would expect to proceed in discussion in terms of your convictions on all of these points, whatever they may be. And that means that such foundational ideas of whatever variety will be communicated, either explicitly or implicitly, in the forms of state speech and in the policies it ultimately enacts and enforces. The fact that government embraces or rejects certain ideas about the nature of reality is inevitable and will be visible. And as a result, both of government messages, be it Gay Pride Month, anti-smoking campaigns, right-to-work speeches, or government policies, be it criminalization of peyote, or mandatory blood transfusions for children who are dying over the objection of their Jehovah's Witness parent, or legislation enacting same-sex marriage. All of these are going to involve folks that dissent from that speech and policy that are ultimately going to be feeling like outsiders. There is no escaping that, and implying that so-called religious speech uniquely presents this tragic circumstance of folks feeling like outsiders. And that then must be remediated by separating religious belief and speech from the state is just perplexing. Any message or policy carries the same potential. There's no getting away from that. So paraphrasing Professor McConnell, there should be no epistemological screening devices in our democracy that isolate certain conceptual frameworks for handicaps that are not imposed on their rivals. As he puts it, the Establishment Clause was not designed to make religion irrelevant to politics, which is an impossible task. And I would add, just as it is impossible to forbid someone to have reasons for acting. The idea that we can or should raid the intellect to purge it of theological precept or religious conviction, or at least to suppress speech that reveals such convictions, is an act of censorship of a particular viewpoint, requiring that those viewpoints be replaced with other, preferable viewpoints. But the role that each such viewpoint plays, be it Christianity or Judaism or Islam or Mill's utilitarianism or Kantian deontologism, they all play the same role. Something will guide and regulate our view of reality and our resulting speech and conduct. The question is just simply, which one? And the follow-up question is there good reason to be treating prejudicially one or others of those belief systems while allowing free public reign to others? So in sum, this censorship model of the Establishment Clause is a very different sort of undertaking from that of maintaining a jurisdictional separation between, or independence between ecclesiastical and civil institutions. So my first 2 points were that the design and history of the Establishment Clause itself won't bear this ill-considered lemon or endorsement construct, which I'm proposing is little more than an exercise in ideological gerrymandering. But my third and related point is that it is otherwise constitutionally anomalous to rule in the ways that these tests require. For instance, to deny that the government has a prerogative to appear to have an opinion on a matter of religious belief, when we acknowledge its liberty to sound off on any other thing it conceives of, no matter how controversial that may be. And it's also anomalous that we would assign legal significance, if only rhetorically, to the unhappy sentiments of dissenters upon their receipt of messages that they disagree with. For example, Circuit Court assertions to the contrary, Article 3 standing rules that regulate when one may bring a case in federal court do not countenance ideological offense or psychic unease as a concrete injury allowing for court access. Indeed, the Supreme Court in the Valley Forge case put it this way: the psychological consequence presumably produced by an observation of conduct with which one disagrees does not constitute injury sufficient to confer standing under Article 3. Further, the speech clause context is one in which offended observers are told flat out, you don't like the message? Avert your gaze, plug your ears, turn your back, walk away. But the Supreme Court refuses to validate in law their offense, because to do so would be to give a heckler's veto to them over the speaker's message, which is the antithesis of the speech clause doctrine. So it's only reasonable then to note the incongruity between that conviction in the First Amendment and the speech clause and what we're now entertaining in the Establishment Clause realm. As Justice Kennedy wrote in his dissent in the Allegheny County case, citizens who disagree with the government's religious messages are free to ignore them or even to turn their backs, just as they are free to do when they disagree with any other form of government speech. And along those lines, I think there's an absence of coherent explanation for why this purported concern about offense becomes a factor of government halting magnitude when the government speech is religious, whatever that category may be stipulated to include. But the presence of a citizen's offense in response to any other government speech, or even its heavy-handed regulatory impositions, is of precisely no consequence whatsoever. Why should the Establishment Clause claimants be uniquely authorized to seek and obtain injunctions against what bothers them when nobody else can? Especially when the psychic pain and sense of outsider status can be far greater for those who, for instance, are sitting in prison because they've purportedly violated a standard of propriety on the state's conception, or for those who watch while their relatives back in the home country are blown to smithereens by American bombers, making the world safe for democracy, or perhaps those who, close to home here, see their theological convictions ruled unfit for participation in public life. Steve Smith has written, alienation produced by Supreme Court decisions may be even more severe than alienation provoked by actions of legislatures or lower government officials. And this is so, he says, because when the Supreme Court cleanses religion from the public culture in the name of the Constitution, it is sending a message to people of faith that their central beliefs and values are incompatible with the fundamental and enduring principles upon which the Republic rests. A rather more insulting message than that that's simply conveyed by a practice by a local community board. On the alienation meter, I wonder whether such Supreme Court justice opinions might register a little higher for certain citizens. But the point again, though, is there's no getting away from government line drawing. As Justice Scalia wrote in concurrence in the National Endowment for the Arts case versus Finley, it's the very business of government to favor and disfavor points of view on innumerable subjects. And as Justice Kennedy said in writing for the court in University of Wisconsin versus Southworth, it is inevitable that the government will adopt and pursue programs and policies that are contrary to the profound beliefs and sincere convictions of some of its citizens. Of course, philosophical and theological neutrality on matters of civil concern is impossible. The state necessarily must choose between competing visions of good and of right and of justice and the appropriate design for community, as it goes about speaking, legislating, and imposing coercive penalties on those that it deems aberrant because of its selected vision of life. All of this communicates messages of approval and disapproval. That is what governments do. So treating state messages and a reasonable observer's awareness of the state's point of view on some question of controversy as grounds to invalidate that government communication when there's no actual imposition on the citizen to speak of is baffling as a standard of legal measure. Now, drawing back down to legislative implications, my 3 points just presented were intended to explain why we need a repair to this jurisprudence. But it's also to suggest that whatever good policy reasons there may be for regulating the invocation practices in our various government forums, those arguments should proceed under a rubric other than that of the Establishment Clause, because the elimination of non-coercive appearances of government favor for certain religious ideas is not the object of that clause, however much we might like it to serve that function. Okay. Having just assailed a fundamental pillar of modern political and legal theory, I'll now step down to a more mundane undertaking, and that's to critique a couple of other things. Although if we need a 30-second stand and stretch break, I could entertain that now as well. Are you with me still? Or? Okay. All right. Shall I proceed? Okay, my first mundane point. Less ambitious. As to the plaintiff's newfangled coercion claim, that they're coerced into participating in a religious exercise. Here are some relevant facts. The plaintiffs are not required to be present at the town board meeting. No one is required to be present at the town board meeting. If they do attend that meeting, they may come and go from the room as they please. This is done all of the time. And by the way, the meeting at which the town board actually hears zoning requests and this sort of thing takes place at an entirely separate meeting 30 minutes after this first board meeting. There's no evidence that any negative repercussions attend to or ever have attended to anyone who didn't attend or wasn't willing to bow a head while the prayer is going on or what have you. The case evidence is that the plaintiffs themselves have refused to bow their heads or stand or any other form that would confuse folks as to what their position is as to this practice. No penalties. So there's no evidence of coercion. But they say to the Supreme Court, we don't need evidence. There should simply be a presumption that this prayer practice is coercive. Here's why. When non-head bowers seek board authorization for something, they're aware of the certain peril that attends to their being non-compliant. So the only way for them to enjoy the full catalog of civil rights that everyone knows only attends to those who bow their heads, they will be coerced into bowing their head during the prayer and thus participating in religious practice that they disagree with. This is the basis for the coercion claim. Now, I don't know what kind of fantastical proposal this is. I suppose what this implies is that the town board is going to have someone up there with one eye open to see who's present or not present, who might have their head bowed, or maybe their eyes open, or whatever it is that's supposed to show you're not participating. And then you write the name of that person down, so when they later want to build a deck on the side of their house, you say, no, you were the guy who had his eyes open during prayer, so we're not going to give you your deck authorization. This is seriously being proposed at the Supreme Court in this case. This is the coercion claim that's being conveyed by the plaintiffs. Not surprisingly, the plaintiffs offer no legal authority for the proposal that the First Amendment requires a legal presumption of such scandalous pettiness and bad faith by government officials. So we might say that their proposal is rather ambitious. Now contrast that proposal with, for example, the Supreme Court's decision in West Virginia versus Barnett. This was the case in which a school administration, which was the thing to do back in the 40s, I guess, required students to both salute the flag and recite the Pledge of Allegiance, on pain of expulsion from school. Expulsion gave rise to further penalties as well. Once you're expelled, then you're looking at delinquency charges. And this attends not only to the students, but to the parents as well. This, friends, is legal coercion that the law countenances. No question about it. This being a means of distinguishing the Barnett case from the plaintiffs in the Grease versus Galloway case are now proposing. But there's another aspect of Barnett that merits our attention in this context as well. The remedy that the Supreme Court granted those school children in the Barnett case is to opt out of participating in the pledge. So while the rest of the class is saluting, this is how they did it back then, and reciting the pledge, they, the opt-out, are conspicuously not participating in that, okay? That is to say, in Barnett, where the coercion was present, the Supreme Court did not order the discontinuance of the pledge ritual in the school. The court did not entertain the idea that students that are now authorized to opt out of the pledge were presumed targets of teachers' or administrators' retaliation because of their non-participation, thus requiring the elimination of the pledge ritual so as to avert that presumed eventuality of coercion. So the very remedy the Supreme Court designed in the Barnett case, the plaintiffs in the Galloway case assert to be a circumstance that is presumptively coercive and unconstitutional. One more criticism of their nouveau coercion theory, and that is that it is strangely selective. They assert first that all prayer at board meetings is unconstitutionally coercive for the reasons that we've just discussed. Yet they then propose that non-sectarian prayer is constitutional. So prayers offered only to God or the Almighty, these are legal, but those that reference a specific deity, Jesus for instance, is unconstitutionally coercive. How can this be? Because, as they explained to the Supreme Court, atheists and polytheists are outside constitutional anti-coercion protection, whereas generic and conventional monotheists are inside the Constitution's anti-coercion protection. I'm not kidding you. This is the argument that they presented. Now, this is their way of trying to harmonize their coercion theory with the non-sectarian view of the Marsh case, but that doesn't make the theory any less, how do I say this, troubled. And the position is peculiar for another reason as well. It hangs out to dry the atheist plaintiff. The legal theory counsel has concocted at the 11th hour at the Supreme Court has kicked to the curb one of the plaintiffs bringing the claim. I'd love to be there for that meeting between lawyer and client. Sorry, ma'am, you've served your purpose. We're moving on away from you now. Very odd. Okay, one other and last related issue of moment that's connected to this non-sectarian idea. Like the plaintiffs here, the Second Circuit below and other circuits before in other places, drawing from the Allegheny County case, have made determinative of legal propriety whether these invocations are sectarian or non-sectarian. But the meaning of those words, seems to me, are eminently manipulable. What is a non-sectarian prayer? Can there be such a thing? If so, what are the boundaries of that category? This, by the way, was something that Justice Alito was pursuing vigorously during the oral argument. Give me an example of a non-sectarian prayer that appeals to all persons of all religions, he was asking Professor Laycock, who was not answering very well. But what they have proposed to the court is whatever non-sectarian is, and they don't quite say what it is, it clearly means there can't be any Christian references in prayer. So there's one approach to non-sectarian. Reverend Palmer, who was the chaplain in the Marsh case 3 decades ago filed a brief with the Supreme Court saying, hey, remember me? In my deposition, I talked about non-sectarian prayers. And his conception of non-sectarian was that which did not hinge on a peculiarity associated with just one denomination, so Baptist or Presbyterian doctrinal uniqueness. That wasn't employed, and because that wasn't employed, my prayers were not sectarian. So there's a second approach to how we might deal with the issue, and I'm sure these fine minds assembled here, we could find another third, fourth, or fifth way of coming with what sectarian or non-sectarian is. But does Marsh require any of this? Well, no. The ruling wasn't limited to prayers that didn't have specific references in them, nor did the Marsh case ever say that that was the principle on which the outcome depended. That wouldn't have been sensible anyway, because it was appealing to this 2 centuries worth of prayers, which were chock full of very faith-specific undertakings. You remember, of course, also the Wiccan priestess in the town of Greece was appealing to Athena and Apollo. Not very sectarian, non-sectarian either, I suppose. The additional problem is, even if non-sectarian is understood as stripped of specific religious references, that hardly makes it universal, does it? You still have, through the exercise of a prayer, say just to God, the idea is being communicated that there is a single benevolent personal God who's both able to hear the prayer and inclined and able to answer such prayers. Okay, is that a universally distributed idea? By no means. That's quite sectarian in itself. Just as is, as I mentioned before, criminal prohibition on peyote ingestion is implying something sectarian, isn't it? I don't know how you get away from the fact that you can't quite make everybody happy all of the time. So I don't know what would be gained by stipulating American garden variety monotheism as the baseline of non-sectarian. You could do it, I suppose, but I don't see the constitutional principle that's requiring that line to be drawn there as opposed to someplace else. The 11th Circuit said in its Pelfrey decision, also adjudicating a legislative prayer, cause of action, we would not know where to begin to demarcate the boundary between sectarian and non-sectarian expressions. Of course not. And the Establishment Clause is not the source of that responsibility in the first instance, which is another reason to avoid this conundrum. It only arises because we're making the First Amendment the cause of trying to make this repair. And that then requires us to come up with some constitutional principle to vindicate the outcome, rather than viewing it more sensibly, as we ought to, as a policy determination that doesn't pretend to be anything other than a response to local preference, and therefore it can adjust as experimentation and public input directs. It seems to me a fine point to tie off with. Nothing I presented today is intended to imply that invocations before government deliberative bodies are not rightly subject to regulation or dispute. My point instead is that we are confusing a policy question with a constitutional question. The Establishment Clause does not forbid this practice, and we should resist the urge to distort the First Amendment provision into a mechanism by which to enforce our modern sensibilities on the intersection of religion and state. If indeed more than mere government speech or appearance of approval is at stake, well then the constitutional remedies are in abundance for such a circumstance. But that is not the circumstance in play in the town of Greece. Thank you for your attention.